I understand the issue. Well, the court heard my submissions about that initial question of whether or not there was as clear a case that
and wasn't very sympathetic.
The particulars of claim. Well, I made my submissions and understood the comments that were made on it.
No, but you couldn't go. The point you're perhaps making is you don't want to make any more submissions about that point.
Precisely, my lord. The court has all the submissions I would have made on that.
Yes.
In terms of the balance of the issues, and I on my feet, I can't necessarily parse it into the grounds of appeal as they're expressed.
No, you don't need to.
The concession that the appeal should be allowed should otherwise be taken as my client no longer advancing the points that are made in the respondent's skeleton argument or the respondent's notice. So those submissions on all of the grounds are effectively withdrawn, and I don't add anything to the submissions I have made.
I mean, let me just suggest this, and then you come in. Would it be satisfactory? Would the parties be content if we were to give a judgment which went along the lines you've suggested? In other words, it said you weren't you agreed not to further the arguments in the skeleton argument against the grounds of appeal. We only heard argument on the first point, and we'll give our decision on that and say what we say about it. On the other points, and then also say what is left open for obvious resolution at the hearing. Because remember, even if we're right about what we said to you on the first point, the second point could overbear that at a trial, in theory.
Yes.
So, and we could say all that, and then we could also say what I think we're quite keen to say, which is that at least we have no business overruling Mr. Justice Linden, but we might say apply some caution to that judgment, because obviously the Supreme Court is binding and Mr. Justice Linden is not. But insofar as the argument was, well, that Mr. Justice Linden changed the Supreme Court, I for one certainly don't think he did, and we feel that could be made clear. So that's what the sort of judgment I was thinking, literally 5 pages.
Yes, Mard. Well, I think from CNH's perspective, if there is a judgment that records the submissions that were made that reflects the submissions that were made about the first point and what the court's decision about that is, then it seems to me that fairly deals with that aspect of it, because for the reasons I submitted, CNH doesn't accept the position is as clear-cut as this court may have formed the view on that first part of it. So if the judgment does reflect both sides on that aspect of it, that deals with the part on which submissions have been heard.
Well, it means that you won't go back to the county court and have an argument about that again, because it will be resolved by this court, and obviously no county court judge is going to contradict that.
Yes, to the extent that there is going forward in the case a question over whether or not the particulars of fraud alleged by Mr. Park identify a problem in the original particulars of claim, and that the original particulars of claim contain what Mr. Park says is demonstrable lie. That's no longer open for argument. Although I hesitate there, as I suppose it depends on how far this court intends to go in what it says about that, and in terms of whether it in effect makes.
But I think the allowing of the appeal by consent speaks for itself very largely. But obviously we can't write the judgment on our feet. I mean, we could give it on our feet, but I think my lady, who would probably be delivering it, might think I was passing her something of a hospital pass if I had suggested that.
Yes.
So what's your view?
Yes, I just want to be clear. you're suggesting that we should proceed on the basis, as my lord suggests, that the judgment would record that it is no longer contended on behalf of CNH that it's an abuse of the process to run the fraud argument.
The concession, my lady, I think doesn't go quite that far in the sense that the allegation of abusive process is in theory still something that the court at trial could consider, but it is not pursued as part of an application to strike out as an abusive process because that's been dismissed by District Judge Woosnam and that order is going to be restored.
Well,
so
that rather bothers me, I'm bound to say, because if we had heard the full argument, we would have to decide whether or not applying the principle set out by the Supreme Court, there was an abusive process or there wasn't. Because either there's an abusive process or there isn't an abusive process, and you either stay for an abusive process or you don't. And the prospect, speaking entirely for myself, that having conceded the appeal, you'd then have another bite at the cherry of saying there was an abusive process, is not something that I find inherently attractive. I thought you were conceding that you were no longer advancing the contention that there was an abusive process by Mr. Park.
By conceding the appeal, it certainly wasn't my intention to do that. But as this is a point that comes up in the course of submissions and discussion, I've not taken instructions over whether that is to be part of the concession that is made.
I don't think you've any choice. I mean, the strikeout is brought on the basis that it was an abusive process to bring the claim. By conceding the appeal, District Judge Woosnam decided it wasn't, and by conceding that his judgment stands, it wasn't. It's the end of it. I don't think you can get around that.
Logically, my lord, I do think that is, I think there would be little, if not no, room to say to the judge at trial, well, we have pleaded it's an abusive process. We tried to strike it out and we didn't get to the strikeout standard on it, but having regard to all the material, it might still be open to you to find it. But I don't think there is, in reality, the room to argue that. So it is not a real prospect that that is ever going to come up.
No, but it may be wise that we make this clear in a judgment. I mean, I think, I think the appropriate course, you having agreed not to offer, I mean, this is if you do, agreeing not to offer any submissions in answer to the appeal, any further submissions, then we give our judgment and you have an agreed order which comes as a consequence of the judgment. You know what the judgment is going to be. It's just as if we'd said, okay, well, Mr. Harding, thank you very much for your submissions, and you say I don't want to make any more, and we give a short judgment and you then agree an order. And I think that's probably better, so that there is no misunderstanding in the court below as to what happened here. We've got your written argument, so we know what that was. You're saying, as I understand it, you don't wish to say any more in pursuit of that argument because you're prepared to concede that the appeal should be allowed. But on what precise basis you don't want to say, because it may prejudice the future from your point of view, but then you have to be governed by whatever judgment is delivered, which you would be anyway.
Yes.
That's really what's happening. So we're in a sort of, we're not in quite the no man's land that one is, as page 1903 indicates, if you just allow the appeal by consent without knowing on what basis, with the case continuing. So I think it's better, frankly, if you just make sure you've got clear instructions that you're not to offer any more argument in answer to the appeal. We will then say now we're going to allow the appeal, give reasons in writing later, and you can agree that order that you've already agreed when you get the reasons.
Yes, my lord. Well, if I could take instructions.
I think you should take instructions. Do you need us to rise, or would you? I'm not keen to rise on account of going up and down with my bad leg.
Yes, Mel, I don't anticipate it taking long, so if I might leave the court to do
But
that.
you may absolutely leave.
And before you do, there's just one other point that's been sort of left hanging over, and that's the question of the bankruptcy proceedings. When I gave permission to appeal in this case, of course I didn't have the power to stay the bankruptcy proceedings, but I did express a view as to what should happen with them. Are they on ice?
They have been stayed by agreement.
Right.
Pending this appeal.
Yes. And that would remain the case, presumably pending the outcome of the county court action going forward.
Yes, I don't anticipate CNH would pursue it pending the outcome of the rescission action.
Okay, good. Well, you go and take some instructions.
Yes, Mel.
And I mean, if it's going to be more than a couple of minutes, let me know.
Yes, Mel, I don't anticipate it will be. I don't know if Mr. King had something he wanted to say and was rising for that purpose.
Mr. King?
Forgive me, I raised for two purposes. One, in anticipation of the court doing so. Secondly, just briefly, in response to my lady's point, in terms of the bankruptcy proceedings, they are stayed pending the outcome of this appeal. If, as seems to be the case, the appeal will be allowed, then the parties will need to take a decision. I only make the point at this stage that Mr. Park would reserve the right to apply to the court to have them dismissed on the basis that they were made in knowledge that there was a real dispute about this, and their, I think, 2018 proceedings that shouldn't be left for so long. I only mention that because I wouldn't want it to be said at a later stage that I tacitly accepted that they ought to remain stayed rather than being dismissed.
Right, you've reserved your position.
I'm very grateful.
Thank you, my lord. I will leave the room to
Okay,
instructions.
you can sit down, Mr. King.
I'm grateful. I was proposing to leave the room with my learned friend, but if the court is
Well, he
happy
may
for me
not
to
want
remain,
you when he's taking instructions.
I'm very grateful.
But you.
obliged for the time. Yes, I have instructions to proceed on the basis that you have just described.
Perfect. Well, in that case, we will, unless Mr. King has anything to add,
My lord, no. Thank you.
we will reserve judgment, having intimated to the parties that the appeal will be allowed. We will not make the order that you've agreed, but you can agree that after you've seen our reasons. And can you, when you do see the reasons, make typographical corrections only, and then agree the order and any consequential directions that you would like us to make. And if you can't agree the order or any consequential directions, we will make those directions, but in writing after receiving your submissions, which you can agree about how they should be exchanged. But that concludes the hearing, and we're grateful to both sides for the argument.